As a constitutional conservative, the default position is that an amendment to the Constitution is a major event and you shouldn't just do that for any reason. So are you a believer that recreational marijuana should be a constitutional amendment, or do you think this should be done through the legislative process?
Well, I believe that it should be through the constitutional amendment because this is a citizen initiative. This isn't a legislative initiative. They have tried for 4 or 5 years to pass this through the legislature, and it has failed. It has hit roadblock after roadblock for whatever reason. They're just not willing to pass it. So that's the reason it's back on the ballot as Amendment 3.
I get that, and I certainly agree with that, but the counter to that is, there's this legal maxim that you don't amend the Constitution unless you absolutely have to, that this might not be the appropriate venue. I personally think this should be a law passed by the legislature, and that the legislature should honor their constituents and pass the laws we want. I don't think that's ever going to happen with the current Republican administration, or probably even in future Republican administrations. And so I think if we don't do it this way, we just got to resolve to never have recreational marijuana. So this internal conflict that I have is, okay, well, if I know they're never going to pass it, do I then bypass my constitutionally conservative principles and then grant the amendment or vote yes for the amendment, knowing that it's not the best way?
The way I resolve this in my belief system is that I believe the Constitution, yes, it shouldn't be, amended every cycle. But in Florida, that's kind of what we do. We have this ballot initiative through the citizens, and what we do there is if the legislature is not going to take the will of the people into account, the citizens take it into their own account. So if your representatives are not able to put forth a plan to do what the will of the people is, then why do we have to sit back and be at a point where, okay, well, it's never going to happen because the majority of the legislature or the governor don't want it to happen? And I think that's where we're at.
Isn't that crazy that we live in a representative republic and then the people we're electing are not representing the people? Oh, it makes me so mad. But I guess that's kind of the times we live in.
I agree. Like the biggest thing for me with this is all the extra tax money that recreational marijuana will bring. And not only that, people that are buying this on the street, recreational marijuana, the potency could be really high or really low. They don't know what they're getting. Whereas it will be regulated with recreational marijuana. There will be a premium price for it, but it will be regulated and there will be consistent potency with it. And I think that's my two major things of the reasons that I kind of support the amendment.
Yeah, I certainly get that. And that's one of the major arguments. Hey, you're going to be having pesticide-free marijuana. You're not going to have to worry it's laced with anything. But man, I have to say, being a black market guy for all these years, well, I didn't smoke when I was a cop, but buying for the black market, I've never had a problem. And I don't expect that it's ever going to be a problem. There's also a counter argument that I heard DeSantis make. Even though Colorado produced hundreds of millions of dollars in additional tax revenue, that money is not consistent and is not coming in the same way they expected it to or something. He's saying that money is not like it was, and that the first year or so it was good and then it somehow dropped off, and that the black market for marijuana in Colorado is larger now than it was before legalization.
The last I heard was, like the states of Colorado, California, Oregon, they all had a boom in tax revenue from the industry. So I have not heard of a fall off.
So you've had a chance to review the amendment. Is there anything in there that you don't like, or anything that out there you say, hey, that I wish they would have done it this way? There's this idea that it was written by Trulieve and that the CEO there has favored, I think they call it the marijuana cartels now is what the term that DeSantis uses, that this only favors big marijuana. What's your position there?
I agree that it does favor Trulieve and these other big corporations that are in the medical marijuana field, because they're the ones that already have the infrastructure set up for this. What I would hope would happen is, if this is passed, the legislature at that point will open this up to more mom and pop shops being able to start a small business. That goes back to your other concern earlier in the legislator doing this. So with this amendment, it makes it legal for recreational use, but it doesn't necessarily go into what laws the legislator can pass after. So I think that this is the first step in many steps. Kind of like the medical marijuana was the first step to get to recreational use. Recreational use is going to be the first step to get to homegrown, get to mom and pop shops being able to dispense, those types of things. We have to start somewhere, and that somewhere, I think, is this amendment.
You know, that brings me back to the point where when medical marijuana passed, the Republican Party under Governor Rick Scott sued to prevent the amendment from taking place. He was trying to ban smokable marijuana. It was like he was an obstacle the entire way through. Do you think we're going to run into those types of obstacles as well, that the Republican Party or those that are against it are going to place additional obstacles in the way, even if the law passes?
And we can look at past conduct to predict future conduct. So not only with the medical marijuana aspect, but even with this amendment, Jeff, we've had the Attorney General of Florida fighting to keep it off the ballot. Even after it had passed the signature requirements and everything, the AG fought tooth and nail saying that this was an unconstitutional amendment and it shouldn't be placed on the ballot. The Florida Supreme Court ruled against them, and it, of course, is on the ballot now.
Yeah, let's briefly discuss that, because you and I both listened to those oral arguments. Maybe I'll put a link to those oral arguments. But the Attorney General's office, probably at the direction of DeSantis, he runs the ship there, and no doubt about it, he's against recreational marijuana. They said that the sample ballot, what the voters will see when they walk into that voting booth, that the 75 words there did not accurately represent the actual language of the amendment, and that it was confusing to the people. And that's where the Florida Supreme Court agreed with True Leave, or went against the AG's office. And this is not the first time the AG's office has stepped in on this. When recreational marijuana came up on the ballot, 2020,
I believe, that it came up.
Yeah, whatever year that came up last time, the AG's office filed a lawsuit to prevent it from being on the ballot, and they claimed before the Florida Supreme Court that the ballot summary was not sufficient. Now in 2024, the creators of this amendment have now fixed that ballot summary. They fixed everything, and the AG's office still sued, even though they followed that exact template that the government asked for last time. I think we're going to run into blockades and barriers all along the way.
As you said, the ballot summary is limited to 75 words, but that's all it can contain. With that being said, it has to be very concise. It also cannot be misleading. I don't see anything in there misleading. I think they're just trying to throw stuff at the wall to see what they can do, because, as you know, this requires a supermajority vote of the electorate to be able to pass.
And that's 60%, right?
Correct.
I think that's a good number. I've heard people talk about that number should be more 66% or a higher percentage.
I think 60 is a fair number.
Sufficient.
I hope that it shows that the majority of people are for or against something. And if 60% are not for it, then it shouldn't pass. I think that's a good number to be able to justify a significant change in the Constitution.
Is there anything in here that you don't like in this amendment that you say, hey, I thought about voting against it, or I'm thinking about voting against it because of this?
Personally, no. There's nothing that has went that far. I believe that there are things that could be better, such as giving access to these license for the distribution centers and stuff like that. But all in all, I think it's a good starting point, a good first step.
Further explain that, because my understanding of the licensure is the legislature is going to have the power to issue these licenses, and the license is only issued to the medical marijuana treatment centers initially, just as a starting point. From that point forward, the legislature is going to have the ability to issue out additional regulations concerning obtaining a license.
That's correct. All that's correct. But there's nothing in this amendment that says that the legislator has to issue a certain amount of license. So, for example, they could keep the status quo and limit the distribution of recreational marijuana just to medical marijuana treatment centers. That's my biggest concern of this.
Oh, so you think that's a likely or at least a realistic possible result that we should be a little bit concerned with?
I do.
Yeah, I can certainly see that. Once again, we talk about those different obstacles the government's going to put in the way, and that's certainly one of them they could. And if they did that, then everything they would say about this being a big marijuana cartel would be true. You know, at that point in time, you would be just funding Truly or these major companies of medical marijuana treatment centers instead of opening it up to small businesses, just like you mentioned.
I was in Alaska about 4 years ago, and pretty much on every corner, there's like a little pot shop. It's a mom and pop shop, usually. It's a one room where you walk in and you can see their display. The biggest part of that was that it was on every corner. So I think that the legislator has a real big opportunity here to make it where it's some small businesses, but not on every corner where people don't want it, like in my neighborhood type of thing. So they're going to have to draw some kind of line, let's say 2 dispensaries per 25,000 people or something like that for mom and pop shops. But they're going to have to figure out a way to be able to do that and still have small businesses be able to distribute, because if they don't do that, like you say, we're just going to make these corporations bigger. Like, it's not going to actually fix the problem that they're complaining of. It's going to make it larger.
One of the points that DeSantis and a lot of the anti-Amendment 3 people are saying is that the language of the amendment, I'll read it, the non-medical personal use of marijuana products by an adult as defined below in compliance with this subject or with this section is not subject to any criminal or civil liability or sanctions under Florida law. That's being interpreted that the government is not going to be able to restrict the personal use. I fell into that belief that the legislator couldn't sanction it at all, even the personal use. Step aside from the licensing for a minute. And so my initial gut reaction when reading that was like, well, if I'm smoking weed while walking down the sidewalk and they tell me to stop, that's sanctioning personal use. And that was my belief. That is not the case. My understanding now is this will fall under a rational basis test. We have a constitutional right, but it's not a fundamental right. And the legislature will be able to restrict use, consumption, possession, so long as it's in compliance with this legislation, as long as there's a legitimate government interest in enforcing the law.
So I agree with you. I think that the government can put some limitations on it. I don't think that this is a ultimate marijuana is free for everybody and the government can't put any restrictions on it. For example, even in the amendment text, when they define personal use, it says up to 3 ounces. So if you're carrying a pound of marijuana, of course, that's not going to be deemed personal use and you still could face criminal liability.
Yeah, so what do you think happens with the law there? So right now, as it sits, the possession of more than 20 grams of marijuana is a felony. So obviously that would go away. But let's say I have 3.5 ounces and I'm driving down the road and I get pulled over. Does that mean because I'm half an ounce over the restriction that it's going to be a felony still?
Good question. I think that the letter of the law will be, yes, you could face a felony charge. However,
and then I guess that's another question there is, so because you now have marijuana possession over 3 ounces as a criminal activity, does that still make the odor of marijuana sufficient probable cause to search a car?
No, there was a law that...
Yeah, that's in the process of changing right now, right?
Yeah, there was a law that came out a few weeks ago that basically said that plain smell was not enough to go into to search somebody's vehicle. Now that's a conflict with another court, so ultimately the Supreme Court's going to have to make that decision of whether or not it's going to keep going forward or not. But as of now, at least in the 6th DCA, plain smell is not enough.
Yeah, I read that opinion again. So we're talking about the plain smell doctrine, and when you smell weed, that gives you grounds to search, or has historically provided grounds to search. And then back in 2019 or whatever year medical marijuana passed, I got really excited because I was like, oh, plain smell is going away because now you have what could be purely innocent innocent conduct cannot be the grounds for a search of your car. When the case law came out within the next year, I was like, oh shit, I got that one wrong, because they're certainly searching cars still for marijuana.
So states have deferred on this, but see a general movement toward plain smell going away.
Yeah.
Especially with the Federal Hemp Act. There's also been a lot of case law on the not being able to distinguish between hemp, the smell of hemp, and the smell of cannabis, because they come from the same plant, or the same plant family. With that being said, that makes it really difficult for the cops to discern whether or not this is innocent behavior or something criminal. Going forward, once they pass the Amendment 3, I think that plain smells will go away. Because I don't believe that you can say that, hey, I see a medicine bottle over there and you may not have a prescription for it, so I'm going to search your car with marijuana.
Yeah, so let's talk about that real quick. So you get pulled over and you have an open container of beer in your center console. That's contraband. You can't have an open container. It's not a criminal violation. That's a civil infraction. Is it your belief that that would give the officer grounds to reach in and take that or search your car just with the open container?
I think that gives the cop at least enough reasonable suspicion, probably probable cause, to do a investigation, because he believes that some kind of...
Well, you got to have probable cause to search. So we're definitely talking, I mean, we got a detention. So certainly they're already detained on a traffic stop. That's valid. I guess the question is, does that open container rise to the level of probable cause to search? And what I mean by search is enter the car, grab that container, pull it out. That would be the extent probably of that search, because I don't think you could expand the search out without additional probable cause.
I would agree with you.
And
I would agree with you on that. I think that they have enough probable cause to seize the contraband, quote unquote,
in plain view. And then I guess the same question would come up, change that open container to just like you said. Now it's a prescription pill bottle. And, you're looking at a prescription pill bottle in the same center console right where the cup holder is. And the police officer can't determine from the outside the name, what's in the bottle, or if anything's in there at all. I don't think that's...
I would agree with you there. I don't think without the cop retrieving the bottle, he could have any kind of probable cause for a seizure or a search, because the law states that he has to be in a place where he can legally see the illegal substance. So if he's actually standing outside and he can see the pill bottle and read it, then I think yes. But if he can't read it, he doesn't know what's in it, which they can't, even though some of them may suggest they can. They have like Superman vision or something. But generally, I don't believe they can actually see that stuff, Jeff. I think that going into a car is a little less protected than house, but still protected situation.
Oh, of course. Yeah, it's much less protected. I mean, the home is the heart. That's definitely the core of the Fourth Amendment right there. I'll tell you, you got your law enforcement experience in the military days. We know it's quite a bit different than the civilian side of it. But man, as a state trooper, as a deputy, I'd be on my toes, looking at the window, trying to find every angle that I could to see as much inside that car as possible in order to generate grounds to search. And you get a motivated police officer like me, or that's just halfway intelligent, knows the law, and knows the ins and outs, and they can quit you pretty good.
I don't know how much you know about it, but I was stationed at Fort Campbell, and I was an MP, so we guarded the gates at that time. It was before they did civilian security at the gate. So we would stop people, we would check their license, all that stuff at the gate, because they're in a military installation. So we didn't really need probable cause to actually just stop them. They're subject to search going into the military installation. So when I would stop somebody, I would just talk to them, kind of like you would do on a traffic stop or a consensual encounter. And a lot of times, like 2 o'clock in the morning, you start smelling alcohol, you start smelling marijuana, stuff like that. So then I have probable cause to actually, do a more in-depth search. So those are definitely things that may be going away with that plain smell as far as the smell of marijuana, because I don't believe that cops can differentiate between legal use and non-legal use. So that's going to be the issue. And if they can't say for sure that it was a non-legal use, I don't believe that just a mere hunch is going to be enough, which is the current state of the law.
Yeah, I don't know if I agree with that. Because probable cause doesn't say that you have to exclude all legal basis. You just have to have facts and circumstances that would lead a reasonably prudent person to believe that something illegal is happening. I would love it if what you were saying was accurate from a personal liberty standpoint, but I think the courts will find an interpretation there that's more favorable of search. I've said this before, marijuana is a gateway drug. It's a gateway to police investigations. I've taught at the police academy. I think my thing back there says I'm like 15 years now or something like that. I've been teaching at the police academy. And a core tenet of police investigations is the odor of marijuana. That's how I taught, or that's how I still do. I teach young police officers to get good at investigations. They start with marijuana because that's such an easy one that they can get their feet wet. It's really safe for them. And then they look at the behavioral mannerisms of the people they're investigating. They have it locked in because they got the odor of marijuana. They're good. But now in the future, they're like, okay, well, I don't smell weed, but I'm still seeing these behaviors. Something's not right here. I need to dive into it. And I think those behaviors manifest, but it's much more difficult to teach those behaviors to a law enforcement officer without the testing grounds of marijuana. And that's going to be really interesting to see how that unfolds.
I'm a little bit more cynical of law enforcement than you. And when I say that, I respect law enforcement, but I believe that based on my years of experience as a prosecutor, law enforcement, and now criminal defense attorney, that law enforcement overuses the smell of marijuana. What I mean by that is there's no way for us to verify whether or not they actually smelled marijuana. I'm sure you've had cases, I've had cases where they say they smell marijuana, they search the vehicle, no marijuana is found, but they found something, a firearm or something like that. And so charges are brought, but not for the thing that they thought that they had a smell for. So I agree that that has been a gateway into the car in the fact that it can't be verified. Such as whenever police officers have other things, let's say they see a firearm, that can be verified. Smelling is not something that can be verified unless they find something. Now, there have been cases I had where they say they smelled it, they found it, no problem. My biggest issue is they use this as a way to get into the car a lot of times, and it's not verified with either an actual finding of some kind of marijuana or another officer, anything like that. It's just one officer's word that he smelled marijuana and then that got him into the car for an invasive search.
I really think this is an exponentially worse problem than what you're presenting. It's almost like that idea of like domestic violence, the unreported side of it. So you just mentioned like, hey, I got this client. The cops searched him for odor of marijuana and found cocaine. They didn't find any weed, but that's a case where the arrest was made. How many searches did that police officer do that didn't result in an arrest, that didn't result in any charges, yet they kept somebody detained on the side of the road, went through all their stuff on the side of the road, had nothing to discover, and then said, oh, on your way. That's never reported anyone. There's no oversight to that whatsoever. At all.
And I hate to criticize law enforcement, but there definitely are law enforcement that are overzealous and they want to either make a name for themselves or just keep busy, whatever it is. And those officers are the ones that are doing these things, or they're approved for federal funding, and they have this special police unit, like the TAC unit in Orange County, where all they're doing is looking for drugs and guns. So they pull over these people, and if they don't have any drugs or guns, then everything goes away. And it's never on a blotter or anything.
Even other crimes. Oh, your DUI? I don't care. Oh, your suspended license? We don't care. Oh, you stole some things? I don't care. We're only looking for guns and drugs. Yeah, I certainly get that. These individual officers are being lured with a carrot. You want to be in the TAC unit? You better make these marijuana arrests. You want to do this specially? You want to get this special overtime? You want to do this? You better produce. The incentivization by the leadership and the federal government through grant funding is part of the problem. I mean, we have a HIDTA task force, high intensity drug trafficking areas. The individual officers are just aggressive police officers, and if you give them a target, they're going to navigate the system and manipulate the system as best they can to achieve their goal. So I don't necessarily think that being critical on the marijuana and critical law enforcement for their searches is critical on the individual officers. These officers are just playing the game using the best strategy they know how given the current set of rules. So, and I don't fault them for that. I did that myself.
And that's the issue, is like a lot of this is the product of kind of what you're saying, incentivizing arrests. As you are aware, like you get awards, you get accolades, you get promotions, all that stuff based on your arrest and convictions and stuff like that. So
you made a big mistake there that it actually furthers your point. There is no oversight with convictions. Like At the sheriff's office, at the highway patrol when I was working there, and I don't know of anybody that ever looked at, oh, you made these 20 DUI arrests or 20 drug arrests and you got this many cases dropped. The only time the disposition ever came into play, I guess two circumstances. If you missed court and you got written up or somebody made a phone call, or I've had circumstances where officers have been caught lying on the stand. They want to make their cases so they get into specialty units. And I can think of one guy in particular, he got caught lying on the stand. And the only reason anybody found out about it is because the judge emailed the leadership at the highway patrol, and that guy got ousted,
Right.
But other than that, zero input onto conviction rate or anything like that. I'm torn whether that's a good thing because, I have a vested interest in the officers not giving a shit. If the officer cares about the conviction, that's going to make my job much more difficult in the back end. And I think we have probably more personal freedoms available to us if the officers are like, listen, I did my job that night. I put forward the best case I could, and I'm willing to tell you the truth about whatever happened. I think that's a much better position than a police officer who's worried about a conviction and will modify their testimony or even maybe continuing to investigate up until the point of trial.
Right.
They could, but you don't get officers doing that very often. And I think that would cause more harm, or at least make our job much more difficult.
I would agree. Like generally, our road patrol officers, once their arrest is made, they don't really go out and investigate anymore. It's on to the next shift, on to the next customer for them.
Yeah, I guess that's a little bit different if you have a detective. If you got a detective who's working a major crime, that's a little bit different scenario. Patrol versus CID would be a big difference there. Okay, so anything else you want to talk directly with the law? I want to kind of shift gears the direction we're going here towards gun ownership. But anything with this law that you want to directly touch on that you don't like or that you like?
One of the major points in the actual written amendment is under subsection 2. It says nothing in this amendment prohibits the legislature from enacting laws that are consistent with this amendment. So this is a first step to make the legislature act if they will. And if they don't, then there'll be another ballot initiative by the people, because if we're not getting representation by our elected officials, then we have to rise up and put forth the laws that we want.
I guess then I'll open that up to one additional question. If the legislator made a law that said no smoking weed on the beach, do you believe that's something that would be held up, or do you believe that's something that would be struck down?
I believe that it would probably be upheld. I think they can limit it to any public use. If they say that you can't smoke marijuana walking down the street, I think that would be upheld.
The whole point of this conversation, you talk about Amendment number 3 with regards to firearms possession and firearms owners. The law changed here recently, I guess 2 years ago? When did the CCW law change?
I think it just went into effect last year.
Yeah, so it just recently changed so that you no longer have to get a concealed carry permit in order to possess a firearm concealed on your person. We still don't have open carry, but that's not without restrictions. Can you give your quick understanding of the current state of concealed carry law, license versus not, and then in your car versus on your person? Once you lay that out, I guess I'll argue with you if I disagree with anything, and then we'll advance the conversation.
All right. Whether it's a license or constitutional carry without a license, the requirements are the same. You have to be 21 years of age. You can't have any felony convictions. You can't be Baker Act or Marchman Act.
One, I don't think our audience can really understand that. So Baker Act is when you're either suicidal or threatening harm to someone else, and you're just not of right mind to be living functionally in society. That's Baker Act. And then Marchman Act is the same type of thing, only through drug abuse. You're so drunk that you can't even make good decisions about yourself, and so they got to take you somewhere for the night. Or you have an addiction to drugs and high on, crack cocaine, and you're making crazy decisions. You haven't done anything illegal except for smoke crack, but they got to do something with you. So that's the difference between the two. So you can't be subject to either of those provisions. And if you were Baker Acted, 2002, that's still going to prevent you from owning or possessing a firearm under this provision unless you've been cleared judicially under that Baker Act and restored back to normal status.
Yeah, thanks for that clarification, Jeff. And also, if you have any conviction for a controlled substance within the last 3 years, you cannot possess a firearm.
Yeah, well, there's restrictions on criminal charges overall. And I think this is a glaring hole that the citizenry, the people listening to this, are going to kind of miss over is if you get charged, even with driving on a suspended license, that is something that's going to prohibit you. Your concealed carry permit may be rejected. The idea is that might be a felony. And the Department of Agriculture looks at that and says, well, if it could possibly be a felony, then we're going to suspend you in abundance of caution. Same thing with battery charges, same thing with drug possession charges like you're talking about. And I think a lot of people overlook that. And I don't think the police officers are necessarily enforcing it. It'd be kind of hard to enforce, but it's certainly an area where people are putting themselves at risk of being enforced.
Correct. So any criminal charges, there is some limitations on possession and concealing. There's also the issue of the cops being able to determine if you're a chronic and or habitual abuser of alcohol or drugs.
Yeah, that's the term in there. I think. Can you pull that language up and see exactly what that says? Because I think it is. If you're a chronic user of drugs or alcohol, then you're restricted. And I think they measure that by like multiple DUI convictions. And there's a few ways they do measure it, but it's not a very good measure. It creates a lot of gray area.
The wording is chronically or habitual. So, and the way that they're able to do habitual is, of course, by the statute. If you're a habitual offender, chronic typically in a medical term means 6 months or more. So if you have a social drink once a month for 6 months, you could theoretically be considered a chronic alcohol abuser. You know, depending on whose definition. I'm not commenting either. So, yeah. But those are the things that we have to look at and decide whenever we're looking at these concealed carry type of situations.
So you just mentioned a couple different things. We've identified the right to carry a concealed firearm with a license in Florida. That right hasn't gone away. And I'm a believer that if you're going to carry a firearm, you should have your concealed carry permit because there's extra protections. For instance, I think I've told you, I took a firearm in 2 different courthouses, and then I took a long knife. I never got arrested or charged with anything from any of those circumstances. 1, because I know how to talk, but 2, because I had my concealed carry permit. If I did not have my concealed carry permit, I would be committed a felony, and they would have been forced to arrest me. The discretion would have been taken out of their hands. But the fact that I had my concealed carry permit made the offense that I committed, it was a criminal offense, but made the offense a misdemeanor, which the officers then had discretion to make a decision to go forward with charges or not. So there's another one aspect of it as well, where, and this is an obscure law, I talked to Mark Conan about this, we did a video on it, where the school system, the federal firearms, or federal school firearm safety act or something like that, prohibits you from possessing a firearm unless you have a state license within 1,000 feet of a school. So, there's several things in there that could apply where a license helps you. So licensed carry, unlicensed carry, but then we have another provision of law, and that's the possession inside a conveyance. It has its own statute specifically for it, and 790.025, I believe. And that one says that you can carry a firearm inside your vehicle as long as it's securely encased or not readily accessible. And so securely case within the vehicle, but not on the person. So let's assume recreational marijuana passes and I don't have my, either way, let's just say I have my concealed carry permit. Is that a problem? Do I got to turn in my concealed carry permit because if I'm going to smoke?
Well, this same thing came about whenever medical marijuana came out. People were scared to get their medical marijuana card because they thought that the government was going to take away their concealed carry permit. It ended up not happening on a grand scale, so I don't believe that it's going to be a problem. The issue is going to become, now the government can trace how much marijuana you're purchasing. Not necessarily using, because who knows what you're doing with it, Jeff, but they can trace how much you're buying. And if they decide that that is an excessive amount, is that enough for them to now go after your concealed carry permit?
I think it was the Department of Agriculture, was it Moody? Who was the head of that? And she had like a social media post where she had her medical marijuana card and her concealed carry permit at the same time.
Nikki Fried,
yeah, that's who it was. So I really don't like that. Because exactly what you're saying is this is illegal, but the chance of it being enforced is very slim.
Correct.
And I don't like that. I like clear language of whether I'm violating the law or not.
Here's the way I rectify it in my head is you don't have ATF sitting at a dispensary waiting for you to come out necessarily. You know what I mean? But if you draw some kind of red flag on them, then they can. I don't put it out of the realm of possibilities with our government to start cracking down.
Just like we talked about in the lead up to this, Hunter Biden. Hunter Biden is being charged federally for lying on ATF form 40, whatever that form is, 4487 or something like that. because he said he didn't use drugs. And then the prosecution, the federal prosecution, went into his social media and went into, his background and identified that time frame that he was in fact using drugs, and then is now prosecuting him for it.
Something I believe that the government can link things together. The issue with the Amendment 3 and marijuana use with the federal government issue. The problem is states and the federal government don't necessarily share information, as you're aware. So that's one of the problems. However, the federal government makes states do it through funding. So, hey, if you want funding for, highways, you're going to have to share all your concealed carry licenses with us, type of thing. So those are things that do have to take into account whenever you're doing this, because even though there's a low chance or low probability of getting caught and that you're violating the law, I do think it's a violation of the law. Like if you're using drugs and possessing the gun at the same time, that is violating the law.
To bring it back to the state level, because I agree with you, the chances of the federal government finding, Jerry Jenkins or Jeff Lotta or individually, unless there's something else going on and coming after an individual, it's a non-issue for the most part from the federal government standpoint. And I think when I looked at this before, it was something like 1,000 prosecutions statewide or nationwide. That's zero. That's statistically zero. My concern is the section of Florida statute that says a person cannot possess a firearm if they're violating a provision of Florida law or federal law. So that seems to connect to make it a state law issue. And once again, I haven't seen that enforced, but it's one of those areas that's just there. And it's like you're always under like this risk of, government overwatch or government attack.
Don't you think the amendment addresses that by saying that any person that's using it for personal use shall not be subject to criminal penalty? Don't you think that would override the statute at that point?
Wait, make your argument again?
But don't you think the amendment where it says that no person possessing for personal use shall be subject to criminal or civil liabilities overrides that statute? Meaning that even if it is a violation of the law, if you have it just for personal use, that would kind of nullify the law.
Right, but they're not charging you under marijuana possession. They're charging you under firearms. So it's not, I think you would be insulated. You can't be charged for having the weed. You can be charged for having the gun and the weed. Yeah. And if they're not charging you for personal use, they're charging you for a firearms violation. Yeah. I don't have a good answer.
I don't have a good answer either,
but the gray area.
If I was arguing this in front of a judge, that would be my argument, is that you can't, in one hand, say that you can possess marijuana, and then the other hand say you can't possess marijuana if you have a firearm. I think that those are...
I don't agree with that. Yeah. I don't think that's a very sound argument, but once again, reasonable people can disagree.
Yeah.
I want to bring up another aspect of this too. So I have a case right now where I have a tourist from out of state and he's down in Florida going to Disney and he's driving, gets pulled over for just a basic violation. The officer smells marijuana and he wasn't smoking weed. He just smells unburnt marijuana. They do a search of him and he has a man purse cross-slung and they find a gun and weed in the man purse. The police officer charged this as a felony using the idea that he could not possess a firearm under Florida's concealed carry laws because he had the marijuana. And I think that's right. But I've seen the state attorney's office drop that charge over and over. So it's almost like maybe the state attorney's office hasn't really done training on that, or maybe they have decided like, hey, we understand this is a violation of law, but we're making a policy decision that we're not going to enforce it. I don't know where they're at there. I do the studying of all this data. It seems like that's pretty consistent that those cases are being remanded to county court.
So in your case, is it he had a concealed carry or did not have a concealed carry?
He did not. Okay. I think that's a great question. So if he had a concealed carry permit, I think it's much like my situation with the courthouse, where it would be a misdemeanor. But if he doesn't have a concealed carry permit, then it's a felony? Is that right or no?
I think so. Because I believe in the statute it says that residents of Florida are able to constitutional carry. There's no right for a person that's here on vacation or a temporary.
You're mistaken on that one. I'm positive on that. I'll die on this hill. It grants people that are here from other states the ability.
Okay.
But either way, I think that argument's the same. I think if you had the concealed carry permit, I don't know. I'd have to look into that and really give that some thought. None of this is really easy.
I think what this all shows is that this is a very fluid area of law right now. With the new law with concealed carry and the Amendment 3, like all of this is kind of new territory for everybody, and we don't really have a lot of answers because this has not been done before.
What about government positions? So you're a police officer. Are you allowed to smoke now? You're a DOT. You're a commercial truck driver. Are you allowed to smoke now?
Well, I think DOT is a little bit different because of they're regulated by the federal government. So that's going to be a little bit different than a city police officer or whatever. I have heard that is no longer a disqualifying factor as far as smoking marijuana for some police agents.
So that is not my understanding. But I don't know on it one way or another. I really haven't discussed it with anybody.
Right.
It was my understanding that they're much like what you were saying with the DOT, because law enforcement receives federal funding, that the drug-free workplace rules apply, and that because of that, if they fail a drug test, it's out. They're fired, and they use that federal money, just like you're talking about with the roadways, to make sure law enforcement does not smoke.
And that may be correct.
I don't know how that worked out. I don't know if that's been challenged.
Yeah, I don't know either. I just tell you what I've heard from a couple people, and they have told me that it is not a disqualifying offense anymore. And I don't know if that means past use or current use. So that's kind of
disqualifying offense sounds to me like past use. So, and what I mean by that, and I think you already know, but I'll share it for the other people. When I apply to be a police officer, one of the questionnaires they're going to say is, when's the last time you used marijuana? When's the last time you used whatever drugs, or what offense you've been charged with? And over the years, depending on the needs of law enforcement, they modify those approaches. So when I first started, you couldn't have any DUIs and be a state trooper. And then I think they modified it where you couldn't have any DUIs in the past 10 years. And now they modified it where you can't have any DUIs in the past 5 years. And it used to be that any hard drugs would be automatic disqualifier. I think that the disqualification for marijuana as a condition precedent for hiring is no longer an issue, but the use of marijuana while employed in those positions would still be prohibited.
That may be the case. I didn't have an in-depth conversation.
Yeah, it's really nuanced. Yeah. So I guess let's cycle back and we'll wrap this thing up here in just a couple minutes. I'm a gun owner. I carry a gun in my center console, and I go to the marijuana shop and I get weed after the amendment passes. When I drive out of there, do I have to be concerned I'm violating the law?
Concerned, yes. And again, a minuscule amount of concern, because I don't believe that the cops are going to be sitting outside of dispensaries like they do bars at closing time type of thing. I think that this amendment eventually will work through the system, and they will find that possession of it at the same time is not going to be a violation of the law. But do you want to be the...
You just never want to be the first.
That's what I was about to say. You don't want to be the first person for that to be decided on.
We'll put our phone numbers on the screen here, and that way, if you have any problems, you can contact Jerry or I, and we'll help you navigate this problem as long as it's in Central Florida.
The safest thing is, of course, to not have the firearm when you're going to the dispensary. Of course, you can't carry a firearm into the dispensary, so that's the safest until the law is kind of worked out. But do I believe that the law was broken? After Amendment 3 passes, and as the laws are written now, I do believe that it's broken. However, I think...
So both you said,
yes.
Right? So as it's written right now, and if this passes, it would be a violation in your opinion?
Yeah, I do believe so.
I agree with that.
It's kind of like you can't be intoxicated by alcohol and fire a firearm. Even though this is just possession.
GUI, gunning under the influence.
Even though this is just a possession, there's a law that basically says that you can't possess a firearm and marijuana. And it doesn't distinguish between medical, recreational, or illegal. Like, it just says you can't possess both at the same time. So I do believe that it's a violation of the law. I do believe that it will be eventually changed down the road. But upon passing Amendment 3, I don't think it's going to be immediately changed.
Hey, Jerry, great conversation. I'll give you the last word if you want to say anything else.
If there is any concerns about these laws, please contact myself or Jeff. I think that the conservative view is, to keep firearms and marijuana separated until we get some certainty with the laws that will be passed in the future. And great conversation with you.
Cool.